Electoral bonds hearing is underway in the Supreme Court. Chief Justice of India D.Y. Chandrachud has questioned the SBI and asked why have complete details not been provided. Supreme Court maintains that all details must be disclosed by SBI. Brian Thomas is joining us live for more details on this story. Brian, what is transpiring in the hearing currently?
Well, Uday, the trial regarding the very SBI of India case has begun. And even the CJI, the Chief Justice of India, has also mentioned that in the previous hearing, SBI was issued a notice, and despite being instructed to provide, complete information as per the order, SBI did not very much furnish the bond, their very bond number, and even representing SBI. The lawyer Harish Salve has also been presented, and SBI has been directed to now adhere to the entire order, including disclosing the bond number to the Election Commission. The court also stressed the importance of transparently revealing all details related to the very electoral bonds, and even furthermore, the Chief Justice of India has also expressed a desire for the disclosure of all information concerning electoral bonds in this very possession, and the conduct of SBI should suggest that the court should specify which information needs to be disclosed. And the Supreme Court Bar Council, Association President Adish Agarwal has also was told by the CJI that the disclosure of electoral bonds was merely a publicity stunt for the Chief Justice. And even the Chief Justice of India also questioned the format in which the data of the electoral bond was maintained. And this meaning, the meaning of storing data in alphanumeric form was also queried, whether it was pertain to security or if there was any other some aspect to it. And additionally, also the CJI has inquired about how it would be known if the bond had been forged, if it was burned. Now it has been decided that SBI will issue the bond number, and they will have to share all the information, and they will keep nothing with them. And regarding the very petition, also the PIL had been filed to conduct an investigation into the electoral bond scheme. However, only a few political parties have very much shared data, and even a certain agenda is being pursued. The Chief Justice of India also told the PB to refrain from debating the ease, and this is and said that this is a constitutional bench, and this matter was also dismissed for demanding information before 12th of April 2019, and it was said that if any information is sought, the review of the decision will be similar to which they are not going to do, and they are sitting here for hearing the review petition. And Supreme Court has also said that it had only made a decision based on the very law. It even asked Rohatgi not to argue, and also there was no need for assistance also, as said by the Supreme Court. And even there was a media campaign also to influence the judge, and even Prashant Bhushan also said that in April 2019, the court has asked information from political parties regarding bonds. However, only a few political parties have shared, and even a certain agenda is also being pursued. And even the Chief Justice has said that the PB was told that he should, debate calmly, and this is a constitutional bench. And even ahead of this, also Solicitor General Tushar Mehta also asked the Supreme Court to consider the issuing of some direction in regard. And even Chief Justice of India Chandrachud says that as judges, they are only on the rule of law and work as per the constitution, and says that the court is only to work for the governance of the rule of law in the polity. And he also further goes on to say that as judges, they are also discussed in social media, but their shoulders are very broad enough to take, withstand all of this, and they are only enforcing the directions of the very justice that is there. Yes, Uday.
Let's listen in to what Chief Justice of India said just shortly ago.
And hence cannot be dealt with in a miscellaneous application. The miscellaneous application is therefore not maintainable and is accordingly dismissed.
I want one more relief to prevent another round of contempt proceedings. Would your Lordship just for a minute have my affidavit in compliance for it?
What is it that you want clarification?
Yes. Marat, there was, when we gave your Lordship, that's why I can see all this story has started. When we gave your Lordship the original figure of 22,217 bonds, we had, by mistake, that was from 1st of April, not on 12th of April. If your Lordship just sees para 4 and Marat, everything will be over, because I know where this is going, where Mr. Bhushan is going. Please see para 4 of my compliance affidavit for 1 second.
Yes.
And please, I would invite your lordship to say, your lordships accept this. We have given the figures, Manan. There is no mismatch, there is nothing of the sort. The total, if your lordship sees the
I
table.
will not go into all that. I mean, there is
I have to convince my lord I have complied with the order. I'm just saying.
It's a compliance affidavit. It's a
We have-
compliance affidavit of your chairman and managing director. We have accepted that.
Please say your lordships have accepted our compliance affidavit. That will put an end to all this.
By the judgment of this court dated 15 February 2024, comma. This court directed, into inverted commas, this court directed, into inverted commas, the disclosure of information on contributions received by political parties under the electoral bond scheme to give logical and complete effect, into inverted commas, complete, to the ruling. Full stop. Thereafter, in paragraph 219, this court issued operative directions. Of these directions, in subparagraph B and C are in two parts. Full stop. Subpara B requires SBI to submit details of the electoral bonds purchased since the interim order dated 12 April 2019, into inverted commas, till date to the ECI, into inverted commas, complete. Such details, the court has indicated, into inverted commas, shall include the date of purchase of each electoral bond, the name of the purchaser of the bond, and the denomination of the electoral bond purchased, into inverted commas, complete. In the second part of the operative direction, in subpara C, SBI was required to submit, into inverted commas, the details of political parties which have received contributions through electoral bonds, into inverted commas, complete, since the interim order dated 12 April 2019, till date to ECI.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.